Soft update on remember that Rekieta has ongoing family issues, criminal issues, and civil issues. And in the civil case, where he's being sued by Steve Quest, a.k.a. Montegraph, for defamation per se, where he accused him of being his civil court judge was Judge Picker, also known as Jennifer Fisher. She was asked to recuse in the criminal case, and by Minnesota state law, you get one free do-over with your criminal court judge. So when they asked her to recuse, she did. She didn't challenge it because he statutorily has one free judgery role, basically, per case. And he believed that it would be a bad idea to let her be the presiding judge. Well, in the civil case, similarly, she has recused, and I believe that this was done sua sponte. She just simply decided that she would like to recuse from this case. And now Honorable Stephen J. Winsel is the judge in the civil case. And if that name sounds familiar, it's because that's the judge in the criminal case. So I believe that may also be the judge in the family case, but don't quote me on that. So now this guy is officially the state-appointed Baldo handler in all matters, legal, criminal, or civil. Honorable Winsel is at the helm, representing Minnesota in these matters. So I don't know what the outcome of that will be. I think there's some reason to speculate that this guy is not on Rekieta's side. Personally, probably thinks that Rekieta's a dickhead. And the reason why I can say that is because of this filing. So when Rekieta was arrested, the first thing that happens in a Minnesota trial, as far as I'm aware, is that they schedule something called an omnibus hearing. Now, you have, between the point of being indicted and the trial in criminal cases, each state and the federal jurisdictions have their own procedures. And there is a timely way to file certain motions, certain challenges, certain requests before the trial begins. Minnesota has a really big hearing, pretrial hearing, called the omnibus hearing. And unlike in a lot of states, Minnesota gets a lot of stuff done in this one hearing, which is why it's called the omnibus, because it's everything. Basically, everything that you want to file before the trial happens at the omnibus hearing. Everything. If you want to file something, it must be done. It must be heard at the omnibus hearing. That's why we sent a bunch of people to this hearing, because it's a big deal. And a lot of things that would be hashed out and set the pacing of the case would happen at the omnibus hearing. So the Kiwi SEAL Team 6 or whatever arrives at the court, gets hassled by Ethan Ralph, waves goodbye to him, so on and so forth. That all happens, and it kind of felt underwhelming. And I was a little bit irritated because I assumed that there would be like a continuance and there would be a second omnibus hearing. Because all that happened at the omnibus hearing is that Rekieta asked for a Franks hearing. And a Franks hearing is named after a Supreme Court precedent where it said that if a police officer lies materially to a judge and gets a warrant, and that warrant would not have been granted if that police officer did not lie, then anything that the warrant obtained would be fruit of the poison tree and would be inadmissible in court. So that means the body cam footage, that means the that they found, that means that the weapons that they found, that means that anything that they found as a result of that warrant would be thrown out, and that's basically as good as dismissing the case, right? So Rekieta said that the cop had lied because he watched the stream of Rekieta up on coke and alcohol on the big on the Anime Sucks Cope and Sneed stream. The judge, Officer Pomplin, said that had happened, and Rekieta asked for a Franks hearing, and his attorney wrote, or some people think that he's writing them, but he wrote and said that Pomplin had watched a stream that was archived on Cognificent, the retard, Jobless Johnny, on his internet backyard or whatever, I can't remember what it's called, on his archive channel. And therefore, he lied materially under oath to the judge, and the warrant would not have been granted if he had said that he had watched an archive. And in part because they said that the stream was edited. and watermarked. And the reason why he said that is because COG on YouTube had added a watermark to the channel, and that's a part of the player. That's not a part of the video. So the way that this works is that he went to the omnibus hearing, he asked for the Franks and nothing else. QE Team 6 walked away. Felt a little bit underwhelming. Then Rekieta files his first motion in support of the Franks hearing, which outlines all the things I just talked about. The state comes back with a reply, says you're full of shit, you're wrong. It's very clear from the affidavit that he's actually being very truthful, very upfront, that he watched an archive. The words have a clear meaning because they appear multiple times. And Hardin even told me that when he was a prosecuting attorney, the quality of Virginia warrant request was far below this. So Pomplin was very deliberate and well-spoken in his request for the search warrant, and it served him well in the trial because Rekieta's reply was rejected, and the judge basically said, you're not getting a Franks hearing, which is on its face a kind of a blow, but it was kind of a long shot to begin with. I mean, it's basically a get-out-of-jail-free card. If he can get the search warrant thrown out over this technicality, then he gets all the evidence thrown in as well, and then he's a free man, and there's no issue. Except his gambit actually backfired horrifically, and I say that because of this. So this is the order. You ready? The defendant's motion to schedule an evidentiary hearing pursuant to Frank's challenge is denied. So he didn't even get to have the hearing that they were going to schedule. The judge says, there's no way I'm going to believe this. There's nothing you can show me to change my mind. It's over. You're denied. Then the defendant's motion to suppress the firearms and ammunition is denied because he raised some kind of challenge about the, oh God, what is it? The plain view. I talked about this earlier in the stream. He said that was not acceptable under the plain view exception to the scope of the search warrant. Judge says that's bullshit. It's in the house. It's in plain view. What more do you want? Or it was in the gun safe or whatever. And then 3, and this is the banger, chat. All other omnibus issues not argued with particularity or otherwise specifically identified to the court as a contested issue at the omnibus hearing, whether included in the written notice or not, are denied, having been waived by the defendant. Now, this was not actually a response to anything in his Frank's hearing motions. This is like a little thing that he's added himself, saying like, we're not having another omnibus. And everybody thought. Bromka from North Dakota and Minnesota, that was one of the Kiwis at the courthouse. Sean thought this. Hardin thought this. Everybody expected that there would be Omnibus and 2 set out where Rekieta could file a bunch of other bullshit to prolong the case. The judge has said no omnibus hearing, which means that because if you remember, Rekieta filed all this shit literally like the midnight before the actual omnibus was scheduled. So he hired counsel last second, filed a bunch of shit last second, got the omnibus hearing, raised one thing and one thing only, the Franks hearing, and then the judge says, like, look, you put this off to the last second to try this long shot. You don't get to go a second bite at it. You don't get to do this again. So, because anything else that he wanted to raise, and he mentions in the Franks hearing motions that he wanted to raise a couple other things in passing. I think the judge even says you made a vague reference to something, but you didn't specifically, bring it up, or you expect to bring it up later. That's not happening. That's what he's saying here. And that means that now there's going to be a trial. They have a scheduling conference. That's the next thing that's set up. And they're going to decide the dates of different things. And that's mostly technical, where they say, well, I'm busy that week, because attorneys have multiple clients.